Thank you.
Of commercial bank of PSC and outside and others. Appeal on behalf of commercial bank of Dubai, PSC and outside and others.
Good morning, my lady. I represent the first appellant. Mr. Leonard to my left represents the second appellant, together with Miss Elves behind me, who is a pro bono junior for the second appellant. And to my right is Mr. Peter KC and his junior, Mr. Trotter.
Thank
you. May I start with brief housekeeping? You should have a call bundle, 2 supplementary hard copy bundles, 2 authorities bundles, a replacement skeleton from both the first and second appellant, and a short note on the applications which we had intimated in our appellant's notice.
But you're no longer making.
Yes.
Can I also say this? I regard the number of pages in the supplementary bundles as wholly excessive. The only reason I granted permission was it was such a late application. So I'm just putting that down as a marker for any future cases.
You have 3 authorities handed up. Yes. 2 are due to errors in the bundle. So that's the former Part 81 that's been handed up from the White Book from 2020. There was an issue over which version of the Deutsche Bank and Sebastian Holdings case went in the bundle, because of course there's several by that name. So that is the Court of Appeal judgment that you have in front of you. The commercial court judgment is in the authorities bundle. And then finally, my learned friends have handed up the case of McKendrick, which goes to sanction.
Thank you very much.
Thank you. Well, may I start with this? It is clear that there's a long-standing and long-running dispute between the appellants and the respondents.
And can I tell you this? We have read the judgments both as to contempt and as to sanction. We have read the skeleton arguments. I'm not even going to pretend that we have read every single page of the supplementary bundles, but we have read, so you have that.
I'm very grateful, my lady. If there's a document that I take you to that you're familiar with, please do move me on. Mm-hmm. Equally, if I'm skipping over documents that you would like to be taken to, I'll be guided by you.
Fine, thank you.
There's no doubt that there is some unfortunate background in this case. There's no doubt that the matter has been long-running. But nonetheless, the main point in this appeal concerns a matter of procedural fairness. If the respondent is correct, then assuming we're successful on the appeal, it will be remitted and they may succeed in their arguments if that is the strength of their case. But the appellants have a right to put forward their evidence and challenge the evidence of my learned friends. I acknowledge straight away that the service grounds were not raised at first instance. Neither Mr. Leonard, Ms. Elwes or myself appeared at first instance. However, I would make this point that we're not in the usual position of a point not being taken over the course of long-running litigation. It was only over a course of a matter of weeks that the appellants were represented in October, November last year. I can deal with the new point, the test.
You do, just to pick up on something you just said, you don't need permission to appeal against a committal, but does that entitle you to take new points which were not taken below when they could have been?
Well, my lord, I think the question of whether we need permission to appeal The answer to that is no, we don't need permission. But the question whether we need the court's permission to run a new point, I think that authority still stands. So we will need your permission to run that point.
The service point.
Yes.
Thank you.
So I can deal with the test for that straight away. If you will then bear with me while I go through the substance of the point, so that you will see whether or not, in the fullness of time, I meet the test, which I can outline to you. That's how I propose to deal with it.
Very well.
Okay. So it's common ground that service was not affected personally after Charles Russell speech fees came off the record in the middle of the contempt proceedings. It's common ground that the respondent served the first appellant by text message, I think specifically iMessage, to a number ending +4488. The test to which this court has to apply to whether to permit the first and second appellant to run this point was discussed by my Lord Justice Mayles in Deutsche Bank and Sebastian Holdings, which is in front of you at page 16, 19 of the judgment.
Which paragraph?
Paragraphs 46 and 47. And if I can, rather than read it to you, I can invite you to read it.
So what are you extrapolating from that?
So I'm saying that the test is whether it's consistent in the interest of justice to allow the appellants to run this argument. And I'm saying the threshold for that is not too high in cases of contempt.
Well, what does that mean? Not too high.
Well, if one looks at paragraph 47, one sees that it is not a ground to refuse permission on the basis that the court doesn't think that the point has reasonable prospects. I mean, we say we're not in that territory on this particular point, but it's a broad test of whether it's in the interest of justice.
I'm sorry, someone was coughing, I didn't hear. It's a broad test.
Of whether it's in the interest of justice. And it depends on the particular case, whether the argument being run is in abuse or whether it's in the interest of justice to allow that point to be taken. Subsequent to that decision, there's been a decision of this court earlier this year in ADM. That is in the authorities bundle, tab 22, page 473. another contempt case where the argument was taken for the first time on appeal that the change in rules had done away with contempt in the capacity of a director. And the question was whether this was a point which could be run on appeal. And paragraphs 94 and 95, again, I invite you to read it.
It's really paragraph 95, isn't it?
Yes, thank you. So there, when considering the interests of justice, one considers factors which include the nature of the proceedings, the contempt proceedings where the liberty of the appellants are at stake, the prejudice that would be caused, not pure point of interpretation of the common law, the procedural rules, doesn't depend on further evidence. And the prejudice caused to the opposing party, well, we're only asking for the orders to be set aside and the hearing to be remitted. So whilst the respondent may consider that an unsatisfactory position, it's a procedural entitlement of the appellants, we say.
Is that right, that you're only asking for the hearing to be remitted? I mean, if you win on service, so that the contempt application was properly served, there's no doubt about that. But if you win on that there needed to be some order for alternative service in the contempt proceedings, and there wasn't, don't the claimants have to start again?
Well,
It wouldn't be remitted. It
Well-
would. They'd have to serve. They'd have to get a date in the court below. They then have to serve notice of that date. Your solicitors might or might not still be acting. They might have to start serving in Saudi Arabia, wherever it is. Not Saudi Arabia, but anyway, where UAE. I beg your pardon. And the whole thing is set back by months and months.
Well, remitted's probably the wrong word because it wouldn't necessarily go back to the same judge. But our position would be the contempt proceedings were served, so there's no need to launch new contempt proceedings. So we go back in time to the point before the 4th of October contempt hearing. There are directions and a hearing, and of course the court has the power to set a timetable according to the justice of the case.
And then another appeal, as of right. So it's going off for at least a year until it's finally concluded, isn't it?
Well, that may be the case, my lord, in terms of the timetable. What I would say to that is this has a point of wider importance, and the question is whether one can serve potential contemners in reliance on an alternative service order granted for different purposes or granted prior to the issue of the contempt proceedings. So whilst there may be some scepticism from the respondent about the outcome of setting this matter back and going through a trial, the reality is the correct procedural rules were not followed, the appellants have a procedural fairness right, both at common law and under Article 6, which applies because this is quasi-criminal, to have the opportunity to challenge the evidence and to give evidence if they decide to. And it's that opportunity which has been denied them.
Would you accept that the interests of justice test might be answered differently according to whether the judge's finding that, regardless of whether there was proper service, the appellants did in fact know of the 4th October hearing is correct? I mean, it's one thing if he was wrong and they didn't know about it. It's another thing if they did know about it, but are taking a technical, albeit correct point on service.
In my submission, no, that would not be a factor in the interests of justice case. Irrespective of the underlying merits in the contempt case, the rule in part 81.5(1) is there to protect all contemners. So the fact that there is evidence against these contemners on the merits, which the respondents are confident will get them home, is not relevant to the point whether the appellant should be given the opportunity.
This is not to do with the merits. This is to do with whether there was service. This is whether you should be allowed to take a service point you didn't take below, and how the interests of justice bear on that, according to whether or not you did in fact know about the hearing date.
Well, the answer to that really is twofold. Firstly, there is no application by the respondent for retrospective alternative service. So that we're not dealing with that issue in this case.
But there might have been if you'd taken the service point.
Well, an application could have been made to this court, and it wasn't, and that point was not taken in a skeleton argument that that was an opportunity denied. The respondent's position is that we are wrong on the procedural service point. The second point I would say is that if you could displace the obligation to personally serve merely because the contemner has actual notice.
Do you mean actual notice or knowledge?
Quite right, my lady. Knowledge. I think that's what my Lord Justice Mayors was referring to. Then you're undermining the fundamental protection. In contempt cases, it is critical that either there's personal service or service on the solicitor if the qualifying criteria in 81.52 is met, or a court has properly considered whether it would be appropriate to make an order for alternative service of the contempt proceedings. And I will come on to it, but I do flag at this point that the first appellant was only served by text message to a phone which he has never replied from by text message. There was one incident about 15 months before Mr. Justice Butcher made the listing order where he answered the phone. There's evidence from the respondent that he answered the phone. But no evidence of actual knowledge that he received those text messages. Now, I was going to address you on knowledge at a later date. May I perhaps do that when I'm dealing with my knowledge grounds? Because that will then feed into why I say the premise that we had knowledge is false in any event, and the judge was simply wrong on his approach to the evidence. We also say this is a compelling public interest point, which the court should seize in any event to make a decision about. So moving, if I may take this service point in substance, subject to your decision whether to allow it in the event. The first service order is in the supplementary bundle, tab 3, page 34.
You've got two service orders, the first by Mrs. Justice Cockrell and the second by Mrs. Justice Hill.
That's right. So the first one, this is Justice Cockrell, paragraph 3. Alternative service order against the first appellant was the PO Box 6600 address. And then over the page there was paragraph 4, service on 2 law firms. It's not in dispute that service address, that PO Box address was not successful, and so that address was not renewed in the Calver order, it was set aside. And there were issues with delivery to both the suggested law firms. Then moving on then to the Mr. Justice Calver order, that's at tab 6, page 68. And you see paragraph 2 renews the balance of the steps in paragraph 3 of the previous order. A number of further steps have been taken by this point voluntarily by the respondents to serve. So permission is given retrospectively for those, and then they are incorporated into paragraph 2.1 going forward. And you see there at 2.1, the first appellant can be served by 3 different means. And over the page, this is where the reference to the mobile phone numbers appears.
And it's the first of the mobile phone numbers, isn't it?
It is, yes. So I don't need to take you then to the affidavit, which confirms that it was only the 4488 number, which was served after Charles Russell came off the record. There's no complaints about the service made under the Mrs. Justice Cockrell order, and there's no complaint about the service that was made under the Mr. Justice Calver order, because notwithstanding all these different provisions for alternative service, in fact, the only way they actually served was on Charles Russell, which was paragraph 2.7. And in any event, the appellants attended that return date before Mr. Justice Calver. So the issue of service at that point did not take on the gravity that it did do later. It's also worth pointing out that it's clear that the first round of service under the Mrs. Justice Cockrell order did come to the attention of the first appellant because solicitors were instructed in counsel for the return date. But it's also known that at that point, I think this is right, I might be corrected if I'm wrong, the first appellant had not been taxed to 4488. I think at that point, the other number had been used, 8511. And I can take.
I think that's right.
Thank you. So at that point,
And you accept that to the extent that this order applies, I know you say it doesn't at the contempt stage, but that it would be good enough to send it to one or other of those numbers.
it's permitted, yes.
Yeah.
So it's served properly
Yes.
to that number. But the point I make is that that number, there was no response to that number, which is why they didn't serve to that number again going forward. They switched to 4488.
Yes.
I think you said that.
So that's relevant to knowledge rather than service. So moving to the law then on that factual matrix, it's a simple point. Can a prior alternative service order made in the main proceedings without more extend to subsequent contempt proceedings? Put another way, can it displace the express provisions in Part 81? We of course say clearly it can't. And the authority for that is Mrs. Justice Cockrell in Erdnet, which is at tab 15 of the authorities bundle. I don't have the volume, the tab to my numbers handy, so I apologise I'm not giving those.
Tab 6, 15.
15 through to 5. And if I can invite you to read the reasoning at paragraphs 42 to 44. So there, the point I particularly wish to emphasise is Mrs. Justice Cockrell's emphasis about the appropriateness of that regime as applicable to contempt proceedings, and the fact that Part 81 is considered a code governing contempt proceedings.
as I understand her reasoning, the particular point she's dealing with is service of the committal application itself. Is that right?
Yes.
Yeah.
Yes, my lady.
There's no issue in this case, but the committal application was properly served on the solicitors then instructed on behalf of both defendants. And there appears to be no dispute that they were aware of that, because if one looks at the order made by Mr. Justice Foxton in January of 2023, you will find it in the first supplementary bundle at divider 13. It's an order dated the 18th of January 2023, and if one looks at the recital, it's on page 130, it's the final paragraph. And upon the application of the first, second, fourth, fifth and sixth defendants by letter dated 3 October 2022 for permission to rely on expert evidence in the committal application pertaining to the civil and criminal law of the United Arab Emirates. So there is acknowledgement, it would appear, of the committal application and of the proceedings.
Majid 3 says he was not aware of the committal proceedings, but I accept that there is evidence that Charles Russell were acting for them and taking steps in the contempt proceedings.
Taking steps, they made a specific application.
Yes, my lady.
So that is 18th of January 2023. That is before Charles Russell come off,
Yes.
but still there is acknowledgement of service and it would appear knowledge.
There's certainly evidence that Charles Russell were aware of it.
Well, wouldn't Charles Russell have needed the instructions of their clients in order to make an application?
Well, my lady, I can only work on what is in Majid 3.
I mean, it might be said, I suppose, that those instructions were given at some earlier stage before December, but even if that is the case, it is inconceivable, isn't it, that Charles Russell wouldn't have told their clients the result of the application. I mean, I know you've got to work with what you've got to work with, but looking at it objectively, it would be grossly negligent of them not to report the outcome, wouldn't it?
Well, yes, I think there are 2 points to address here. One is the Majid 3 statement that he wasn't aware of the contempt proceedings. And I have to accept that there is strong evidence for thinking that that may be incorrect. However, there are a number of reasons why it may be incorrect, which are not just consistent with him telling an untruth. The second point that my Lord Justice Mayles raised was the timing point, because Majid 3 also says the last communication we had was in December. I think the application was made a couple of days after the last communication was said to have happened. So that's consistent with that being an earlier discussion. And then, of course, the hearing before Mr. Justice Foxton wasn't until some time later. I accept my Lord Justice Mayles' point about the difficulty on those points. What I do say, however, is that is essentially a red herring, because the key point is whether they had notice of the hearing. It was not Mr. Yates's application on behalf of the appellant to set aside the contempt judgment on the basis that they didn't know about that they weren't properly served with proceedings, and it was emphasised that they weren't aware of the hearing. So I say my points on service and knowledge, sorry, I call it knowledge, do not turn on whether they had knowledge that there were contempt proceedings. Majid accepts that in any event that he knew they'd been intimated. Our point is very firmly on the fact they didn't have notice of the hearing. And of course, when one stands back and thinks about what the rules of personal service are trying to protect, it's not just trying to protect the fact you have the arguments made against you in the application notice, but also protecting your right to then appear at the hearing where it's going to be determined on what basis of any you're in contempt, and in particular, whether on those findings a committal application is justified. There's authority for that in the form of Chiltern District Council and Keene, which is at tab 1 of the authorities bundle, page 6. And I'll just take you from letter F. The issue here was Mr. Keane was aware of the hearing, tendered and asked for it to be adjourned. There was no date set at the hearing. Notice of hearing was then sent out subsequently, and Mr. Keane's response is summarised there, which is very much quite akin to a dog ate the homework type of explanation. For why he missed the hearing. And then the Court of Appeal go on that they can understand why that letter was treated with an element of scepticism, but whether he knew or not, that they accept that it wasn't sufficient in any event that the notice of hearing was sent by post when the rules are such that it has to be personally served. And of course, from the respondent's point of view, it protects the respondent as well when you have personal service. Whereas sending text messages to a 78-year-old man's phone that you've not had a reply from in a language that is not his own, and not having read receipts for those messages, which is something I'll take you to shortly, is very different from personal service. Even if personal services is rejected because the person doesn't want to take the particular documents, you at least have direct evidence that it has come to their attention.
But you're not saying, are you, that only personal service would do? I think you're saying that there could have been an order for alternative service, but it had to be in the contempt proceedings. Is that your position?
Yes.
Yeah.
And if one has a sliding doors moment and thinks about what order might have resulted at that point, I say it's inconceivable that permission would have been given only to serve the first appellant by text message in English to a number that they'd never had a text message from. It is inconceivable that a judge would not have said, as Mr. Justice Butcher did after the 4th of October hearing, that they must take all means possible to inform the appellants of the outcome of that hearing. And so in our sliding doors moment, to inform the appellants of the date of the hearing. And again, I emphasise that when all those steps were taken after the 4th of October hearing, the appellants did engage. They instructed solicitors and counsel. Now, Mr. Justice Butcher did not find that point compelling, but I do say it is relevant that when multiple steps were taken to serve the Cockrell order, they engaged and responded, and then when multiple steps were taken, well, when they were served on their legal representatives, they engaged, and then when they were served by multiple means following the 4th of October hearing, they also engaged. And the period in the middle where they weren't was when the first appellant was only being served by text message to this number. I wanted to just take you briefly, if I may, to MBR and Acres, which is at tab 19. The point is at paragraph 72 on page 406. Just the first sentence, and the issue here is whether the rules being redrafted post 2020 in part 81, so as to remove express reference to director liability, meant that director liability no longer existed in contempt proceedings. And here, Mr. Justice Nicola says that the issue with service of the injunction order, sorry, not directorial liability, I apologise, that this is on the question of whether service of the injunction order, the original order, in this case by Mrs. Justice Cockrell, still had to be by personal service because that had been taken out of the new part 81. And Mr. Justice Nicola considered it was substantive requirement of common law of contempt, and that's at 73 as well.
It's paragraph 102, really, isn't it? That's where he states his conclusion.
Yes, I refer to 86, 87, and yes, 102 onwards. And so relying on that authority and the Chiltern and Keene authority, I say the case for personal service of a notice of hearing is exactly the same, if not stronger, because that was never part of the express requirements of the old Part 81. So its absence from the new Part 81 is simply not material at all. And if one turns to the current Part 81, it's at tab 87 of the authorities bundle. That provision is 81.10 on page 548. So the way subparagraph 1 is phrased, unless the court directs otherwise in accordance with Part 6, except as provided for in paragraph 2, a contempt application and evidence and support must be served on the defendant personally. Putting aside paragraph 2, which doesn't apply to the notices of hearing, unless the court directs otherwise, must mean unless the court directs otherwise, service must be personally made. So you the unless the court directs otherwise has to refer to the obligation to serve personally, which is in 81.54. So what you're looking for is a specific direction that you don't have to serve personally. And that, of course, has not happened in this case. The reference to part 6 is merely a reference to the mechanism by which the court will direct otherwise. So previously, I think it expressly provided for a power to dispense with service, and now the principles on which the court directs otherwise are contained within Article 6. The final authority to refer you to on this is the Court of Appeal late last year in Westrop, which is Authorities Bundle, tab 20, and the page is 431. And the paragraph is 29. The compliance of this particular rule is not merely a technical requirement. The rule they're talking about there is an analogous rule of personal service in Part 71. So it's a different rule, but the consequences are contempt and potential committal. And that paragraph, I say, squarely applies to Part 81 as well. So did the second service order apply to the first appellant? I say no, that issue was decided in Erdnet, my submission correctly. That case is still cited in the current edition of the White Book. For your notes, that is tab 27, page 549. It is also cited in Grant and Mumford on civil fraud for the same proposition. At paragraph 35069, for your note, that is tab 29, page 588.
So the essence of your point, if I've got it, is that if there was to be any application for alternative service, it should have been by way of a separate application specific to the committal proceedings. Is that it?
Yes. Both by reason of the wording of 81.5 itself, and by reason of the authority of Erdnet, which still applies, and also by reason of policy, so Chiltern and Keene, Westrop.
And the policy being, given what is at stake in such proceedings, and the essence is it should be personal service unless particular applications are made.
Yes.
Is that fair?
Yes, thank you, my lady. And also, I will just flag again that Article 6 criminal rights apply to this case, and one of those rights is the right to challenge the evidence against you. If you're not served properly, either personally or pursuant to an alternative service order where a court has scrutinised whether it would be fair to make an alternative service order, then you are potentially being denied that opportunity, which is exactly what happened in this case in my submission.
Well, if you have in fact been served with the original committal notice, and if you do in fact know the date of the hearing, then you are perfectly well able to exercise your Article 6 rights if you want to, aren't you?
If you have actual knowledge.
Yes, I mean, that seems to me to be, as I said earlier, a key question, which no doubt we're coming on to.
Yes, I'm just headlining those points. Because the issue of knowledge was decided summarily, which itself is an issue of some concern in a contempt-related hearing
Summarily.
without hearing oral evidence. So it's decided on the papers.
Well, that was the appellant's choice, wasn't it? They could have come and given evidence.
Well, they put in Majid 3, which firmly stated quite clearly that they did not have notice of the hearing.
Yeah, and they weren't believed. But he could have come and said that and been cross-examined.
But that application for cross-examination was not made. And he was disbelieved on the papers without being given that opportunity.
He had the opportunity to come. He had a right to come and give evidence. He could have done that.
Normally in set-aside applications, indeed in this case, there's no question of oral evidence unless there's a specific direction. I would just make the point that in general, when the court is considering alternative service at the start of proceedings, they are faced with one set of facts. When the court is faced with an application for alternative service for contempt proceedings, the facts have very likely evolved, and of course the balance of competing factors is very different because of the liberty of the respondents being at stake. So that is good reason why you would have 2 stages for alternative service. The alternative is that at the onset of any case similar to this, the judge at the outset will need to consider whether the order should expressly exclude contempt proceedings or not.
So where are we going now, Miss Pugh?
Sorry, I'm just checking where I'm up
Yeah,
to.
you check.
There's just one point on the facts. I'm just trying to find my note about sorry, if you just give me I'll deal with that. If you just turn to the judge's actual order then, in core bundle tab 7. No, sorry, judgments at tab 8. You see that the question of service is mentioned on page 85, paragraphs 3 to 5. just reading the first sentence of paragraph 3, the first consideration is whether the respondents have been served with the relevant documents, including notice of this hearing. That, in my submission, was the wrong starting point, because it meant that the court proceeded on the assumption that if they have been served in accordance with the alternative service order, then that would have been good service. And so by starting at the factual inquiry of whether that had happened, the court missed the first question, which is how should this notice of hearing have been served? And while I'm here, I'll also flag paragraph 5, where the judge deals with knowledge. And essentially the judge's reasoning there is that because they were served, they had knowledge. But of course, that entire conclusion flowed from the false premise that they were served in a proper, lawful way. One point, just very quickly on evasion, if I may. There were allegations against the first appellant that he had evaded service in the past. These, in my submission, require further scrutiny. In headline terms, he was not involved in the BVI proceedings. So when drawing inferences from behaviour in those proceedings, those do not attach to the first appellant. Secondly, the judge also placed weight on the extraordinary account of delivery on one of the law firms, where an associate, I think it was, of Jones Day, is said to have received threatening text messages, which on any view is wholly unacceptable. But there is no evidence that that was the first appellant, or indeed either of the appellants. The only hook they have is the reference to calling the client. There's no evidence that that call was made. There's no evidence that the following phone calls were made on the instructions of the first appellant. So I say that is not evidence of service either, of evasion of service either.
Have you said everything you want to say about knowledge?
Not. Sorry.
Because you were dealing with that, but I'm not sure if you're coming back to it.
I might come back to it under 39, but if my lord has a question.
No, it's just that at some point you'll need to deal with what the judge said in his second judgment at paragraph 30. But perhaps you're going to deal with that under CPR 39. If you are, don't go out of your course now.
I can't remember off the top of my head what paragraph 30.
That's where he
You'll
talks about
forgive me.
the solicitors who are instructed in relation to the bridge properties and knowledge of the hearing of the 4th of October through their involvement.
Oh yeah.
Which is not service, but is knowledge.
Again, that is an inference that is drawn by the judge, which is unsubstantiated by the evidence. the evidence is that security law were instructed to facilitate access to get some documents, I think, and belongings from the Briggs properties. Their response was that they're not instructed in any other matters. There's simply no evidence that that would have led to any discussion about the contempt proceedings. It would have been perfectly plain to security that there was a very complicated background and multiple proceedings ongoing. They may well have assumed that the first appellant knew about it. So I think that the fact that they were instructed on a niche point does not establish knowledge. If I can move on to Rule 39.3, because I think rather than going through it makes sense to look at them through the prism of 39.3. I can take this point relatively swiftly, the first point, which is if you're with me on service, I say 39.3 doesn't apply. And the only just outcome is to set aside those orders. My authority for that is Nelson and Clear Springs, which is at tab 6.
I'm sorry, I just didn't catch that.
I'm sorry, tab 6,
Thank you.
page 64. Paragraph 35, fourth line down. The essential question is whether this is a situation to which Rule 39.3 applies. And then to accede to the submission that it does involves disregarding the complex provisions for service of process under the CPR, and holding that notwithstanding the fact that he has not been served, the burden is on the defendant to establish their criteria. Now, I accept that this is a case involving service of proceedings rather than service of the contempt application, but I say the same policy applies to service of the notice. It is wholly unjust to require a potential contemner to go through 39.3 if they did not get service in the first place, because that is the role of the respondent, and if the respondent has ticked that box, then the potential contemner has to go through 39.3. But if the respondent has not, then it's wholly unfair and unjust to require the contemner to have to go through 39.3. And the conclusion that that's not what the draftsman intended is at paragraph 39 on page 65. So the whole of CPR Rule 39.3 contemplates a trial in the absence of a party who's been served under the rules, or in respect of whom service has been dispensed with. The result of that is that you have a broader discretion, or the judge had a broader discretion. And that is at paragraph 48 on page 67 and paragraph 50, where the judge says an error of procedure could be regularised or waived, but the just order will almost always be to set aside the judgment. That's at paragraph 15. Paragraph 50 also then references prejudice and how it would be appropriate to refuse or to exercise the discretion so as not to permit the order to be set aside if there is no prejudice to the party who was absent. But of course here, there plainly was, because there were contempt findings which were severe enough to justify committal sentence of the maximum sentence. So the rest of my submissions are on the assumption that 39.3 does apply. Subject to this caveat, after filing my skeleton argument, it came to my attention that there is a first instance authority that says it's actually not 39.3, but a different rule that applies. Just trying to find, apologies, try and find that. So that's it's rule 23.11.2, and the case is Russian Commercial Bank. I won't take you to it because the case says whichever one, the test is the same. But for your notes, it's paragraphs 32 to 36. And it's an authority, it's tab 16.345. So having drawn that to your attention that it may be a different rule, the test is the same, so I will proceed on that basis.
So sorry to interrupt, Ms. Peer, can I just check whether I'm following what you're saying so far? So is the effect of your submissions that the application that Mr. Yates made in front of the judge to set the committal side was misconceived?
Not misconceived, but may have proceeded on the wrong rule if one considers Russian Commercial Bank or Shivlov.
Oh, I see.
I can take you to that, my lady, if you would like that at this stage.
Well, I mean, you must you must decide how to do your submissions. I'm not going to.
Okay. Well,
I know much less about it than you do. So
if an issue arises from my learned friends about that, I'll
You
deal
can
with
deal
it
with it.
in
Right.
reply.
So I don't assist at all. I think what my learned friend is saying, and I think I would agree, is
Yeah.
that the test which her predecessor asked Mr. Justice Butcher to apply, and
yeah,
the one that Mr. Justice Butcher did apply,
yeah.
under the misnomer CPR 39, was exactly the same test as my learned friend is saying is the correct test under CPR 23.
Oh, I
So
see. Okay.
it doesn't really matter that the wrong CPR was cited, I think is what she's saying, and I
Right.
would respectfully agree with that.
Okay, that's really helpful. That's me being slow. Thank you.
Not at all. I'm probably drawing your attention to corrections, self-corrections that are perhaps not necessary.
All right. Thank you.
So on set aside, I say that the judge was wrong in principle not to apply the guidance set out by the court in Bank of Scotland and Pereira, which says that you apply the criteria in 39.3, but with 3 factors in mind. That judgment is at tab 8 of the authorities bundle and page 92. So if you look at paragraph 26, tab 8, page 92. first two. So the strictness of this trio of
I'm
hurdles.
so sorry. Which paragraph did you say?
I'm sorry.
No, you did say it. I just didn't catch it.
26.
Thank you very much.
So first of the trio, what constitutes promptness and what constitutes good reason for not attending is in each case very fact sensitive, and the court should, at least in many cases, not be very rigorous when considering the applicant's conduct. Similarly, the court should not prejudge the applicant's case. And secondly, like all other rules, Rule 39.3 is subject to the overriding objective and must be applied in that light. That was then considered in another Court of Appeal judgment called Mohan Smith. I've got TBO written down, which probably stands for something, but my note doesn't extend to that. But it's at tab 14, page 313. Starting at paragraph 24, if I may, the court recognised that an appellate court should be slow to interfere with the decision of the lower court on the question of whether a litigant had a good reason for not attending a trial. Such a decision is fact-sensitive evaluation made in the light of all the circumstances. It is the kind of decision that an appellate court will only strike down for reasons analogous to those which justify interfering with an exercise of discretion. But in making that assessment, the judge must have regard to the guidance given in the Pereira case and the estate acquisition case, which is similar, and the need, when applying Rule 39.35b, to seek to give effect to the overriding objective of dealing with case justly and to comply with Article 6 of the Convention on Human Rights. Particularly important in that case where the prospects were good. So from those two authorities, I draw this submission from that Mr. Justice Butcher ought to have had regard to Pereira and applied those principles. He didn't, and I say that was an error of law, which plainly could have made a material difference. In contempt cases in particular, it's not in dispute, it's common ground that there's a high standard of substantive and procedural fairness. I quote at paragraph 31 of my skeleton argument, Navigator Equities and Deripaska on that. It's not in the bundle because it's not an authority that's in contention. And that stands for a high standard of substantive and procedural fairness in contempt. I should also refer you to Rule 39.
Do you have the paragraph in Navigator where I said that?
Oh, sorry, my lord. I've got it, paragraph 31 of my skeleton. So
If it's in your skeleton, that's fine. That's
I've
fine.
done.
That's all right. It'd be easy enough to find.
I've done my job properly. At 79, 132 and 138. I can send a copy to the court if you...
No need, so far as I'm concerned. I don't think it was original in that case anyway.
I beg your pardon?
I don't think it was an original comment in that case anyway.
Can I just ask a question, please? Was Mr. Justice Butcher referred to the Pereira case by the parties?
I'm not aware of that.
That is the checklist.
I'm afraid I can't answer that question affirmatively. It didn't look like it from my reading of the papers.
Yeah.
But
Because he was represented by, I mean, the point is that the appellants were represented by counsel at that hearing.
yes,
Yeah, okay.
thank you. Acting promptly, the first criteria under 39.3, we say the judge made a material error in how he calculated the chronology. He sets out that chronology at paragraph 16 of his sanction judgment, which is at core bundle, tab 10, page 106. Paragraph 16. Invite you to read paragraph 16. Mr. Justice Butcher therefore took the relevant period as from point of service to service of the skeleton argument, the last working day before the adjourned hearing. In my submission, that was wrong. The relevant chronology was between service of the order of Mr. Justice Butcher and attendance at the sanction hearing, which then was adjourned. And that period is 17 days. Now in that 17 days, the respondents had to overcome a language barrier because the papers, the letter stand corrected, but they were served in English. They consulted local lawyers. They then contacted, through the local lawyers, English lawyers, who then had to go through the legal aid application process. So, sorry, may I just turn? Oh, I apologise. Apparently, it wasn't legally aided at first instance.
No, it's
Sorry.
just for this court. It's just for this court.
Yes, yes. Thank you for the correction. So they contacted English lawyers, and that was all done in only a 10-day period. And then, of course, instructions had to be taken in what is on any view, quite a complex case. When one looks at 17 days, in my submission, that is plainly not acting dilatory. And I take that as being the relevant date as well, because it was clearly intimated that a set-aside application was going to be made. And one sees that from the judgment of Mr. Justice Butcher on that day, which is at Supplementary Bundle tab 31, page 432.
The fault is mine. I've clearly got the wrong tab number. Can I just have the tab number again, please?
Oh yes, sorry, 31. Supplementary bundle.
No, I have it.
And it's paragraph 2 of the order. The only reason being unaware of the hearing is even relevant is if they're discussing an application to set aside. It wouldn't be relevant in any other context. So I say that was a material error and that the judge was plainly wrong in the miscalculation of the period there. Good reason, if I may move on to background. This covers knowledge, which is grounds 1, 4 and 5. I'll deal with ground 6, deliberate non-attendance, and ground 7, the inference that the appellant shared information as well. The one authority I would like to refer you to on this is Masri and Consolidated Contractors, paragraph 144 to 146, and that's at tab 9, page 144. And if I can invite you to read paragraphs 145 and 146. So the finding of actual knowledge is based on inference only by Mr. Justice Butcher. And I say the principles applicable in Masri are applicable to his findings of fact, or which are the result of an inference. And that inference has to be, therefore, compelling, such that no reasonable person would fail to draw it. What Mr. Justice Butcher was faced with was not a case where the first appellant had ever responded by text to, or responded by any other means to a text. So you see cases where, like the Chilton and Keane one, where the respondent asks for an adjournment, which isn't granted, and then doesn't attend the hearing. There's actual evidence there of knowledge because they have made an application to adjourn, which hasn't been granted. It's not a case where submissions were sent in writing for the hearing. It's not a case where the first appellant responded to the jurisdiction evidence and the summary judgment evidence, which was also served to that number. There was no response to any of that. So in my submission, if he had responded to those, then there is a compelling inference that he's cherry picking what he is reading because he's receiving all the messages to the same number and he's only responding to some and not all. But there is no evidence in this case of a response at all to any of those. And of course, it's not a case where he was personally served. So I appreciate I am proceeding on the assumption here that he was properly served, but we don't have that direct evidence that we would have in other cases of personal service and therefore actual knowledge from that. One point about the read messages. try and find where I've made this note. Perhaps I can give you the references later, but the point I wish to make, if I may, is that the evidence from Mr. Richards for the respondent was that the first appellant had, I think, received and read, definitely read, all the messages. My learned friends quite rightly identified that that's not what the evidence shows. There is a stream of text messages, and the only read notice is at the last one. And the last one is 10th of October, post dating the contempt hearing. Now, my learned friends, in their skeleton argument for the 20th of November hearing, flag this in a footnote. So if one turns to supplementary bundle, page 652. There, paragraph 7.2. And it says materially page 652, my lady.
Yeah, sorry, it's got tiny numbers.
Yeah, you must tell me.
Yeah,
please,
no,
without
no.
going too fast.
Yeah.
7.2 of the iMessages, materially similar iMessages to the email were sent to the first appellant by iMessage. And then you see it says they were delivered and returned a red notification. And then there's a footnote there. If you go to footnote 6, it says, although the read date is 10th of October, so after service of the contempt, that is how iMessages work. Read only appears after most recent message. That illustrates that the phone number is monitored. Well,
Read.
it says, I was just reading, it says monitored. That might be the submission of respondent counsel, but there is no evidence of read messages in respect of the others.
So can I just make quite clear what the position is about this quite important point? I imagine it won't be in dispute because it is notorious knowledge. When one has a series of texts of this sort, then although one might be read on one day and it then says read, if another one is sent, then that read vanishes from the earlier text. And so if you look at the train of text of this sort, it's in the very last one that you see the evidence of it being read, because it just naturally, it automatically deletes the word read after the previous ones. So the fact that on the chain of texts which I may show the court, one sees a whole train of them which show they've been delivered, but the fact that it doesn't say read after the early ones doesn't mean it wasn't read, because the word read just simply vanishes. It's only the most recent one, as my learned friend said, will still say read on it to refer to the most recent one.
But it doesn't show, does it, that they were read before the 10th of October?
It doesn't show it either way,
No.
because the evidence that would have been, if they had been read, the word read unfortunately goes.
Yeah, yes.
So,
So
yes,
it doesn't show it either way.
it doesn't show it either way. Just hope that's not in dispute.
It's not accepted that that's how iMessages work. But the point is that there is no evidence. There's evidence they were sent, but not evidence that they were read or when they were read.
Evidence they were received as well. Except, also quite important, I think you're accepting they were received on the system, even if you're not saying your client read them.
Well, as far as I'm concerned, we have a train of text messages, which I'll take you to. Sorry, they were, I do accept that they were, I accept there is evidence that they were received and read, because the screenshots of the message chain have been provided from Jones Day. But what I can't accept is that they were received and read prior to the 10th of October, or that they were read and understood as opposed to just received by the phone. There's simply no evidence on that, I say.
That's something which is in particularly within the knowledge of the second appellant. So he had an opportunity in Magic 3, as I think we referred to it, to give evidence about this, and he didn't.
Well, Magic 3, though, does say that the first and second appellants did not have knowledge of the hearing.
Yes, well, that's a general statement. We're dealing now with specifics of evidence.
Because Mr. Justice Butcher's order, which we were looking at not that long ago, made specific provision for witnesses dealing with the question of knowledge, and you say that that's an adequate response. G3 is an adequate response to that. Is that your case?
So I think, let's see, I think I found the messages. I think my point about this is one of chronology. So the evidence from Magic 3 went in 10th of October.
Yeah.
And it was only subsequently that the other side adduced the evidence of the text messages in the 13th witness statement
I
of
see.
Sean Edwards, which I think went in on the 15th, maybe.
15th of November.
Oh, I'll go for 15th of November. And then the further witness statement from Mr. Richards went in, I think, the day before. So there was very little opportunity to put in any further evidence if they'd have wanted to. There was no realistic possibility of an adjournment being granted a second time for that further evidence. But it would be unfair in my submission to criticise Magic 3, which was prepared more generically before Sean Richards' witness statement 13, to criticise it on the basis it didn't deal with this subsequent evidence.
All right.
So one thing that this red message does show, therefore, is that the phone was still in use as at the 10th of October. So it wasn't the kind of case where it was dropped accidentally in the North Sea, or perhaps I should say the Red Sea, or no longer in your client's possession. And that's right, isn't it?
Yeah, there's no evidence of that, no. The messages that I've kept alluding to without being able to find the tab or page reference for, I've now located. So if I can take my lady to that supplementary bundle tab 35, page 551. And to some extent, there's nothing to see looking at these, in the sense that you won't find any read messages until the very last one. But what I will point out is that there were, even the messages that were sent, sometimes they were sent for the attention of the first appellant, sometimes they were sent for the attention of multiple appellants, multiple defendants. So on page 554, it was addressed to Mohammed, the third defendant as well.
I'm so sorry. So how many defendants altogether? 3.
I beg your pardon.
I'm sorry. You said multiple defendants. I just wanted to be clear how many you meant.
So there's some messages to the third defendant and the first
Right.
appellant,
So that's two defendants.
and then there's others with page 564, which were sent for my attention, for the attention of the second appellant,
Right.
and to Fal Oil Company and Investment Group Private Limited, which
Right.
I think are also defendants as well.
Okay. So that's five defendants.
At various times, yes.
Okay.
And then the only one showing receipt is on page red is on page 576. This is a point in my submission that Mr. Justice Butcher did not take into account. His judgment was that all the messages had been read. That was his finding.
I think I should possibly say, as you mentioned Fal Oil and it then rang a bell, I think back in the day I acted either for or against them. I'm afraid I can't remember which, but anyway, it was a very, very long time ago. I just put it out there for completeness.
Thank you, my lord. So when it comes to knowledge, I say there was just inference over inference. Now, there may well be an unfortunate background to this case, and it may be that these appellants have not behaved in the way the court would expect them to behave in the past. There's, for example, the alleged evasion of service in the BVI, albeit it doesn't attach to my appellant. But the key here is that the only question before Mr. Justice Butcher was whether he was satisfied there was actual knowledge by the first appellant. And so all that background information and context, which no doubt the respondent emphasised at the time and will emphasise again before you, is not in itself sufficient from which Mr. Justice Butcher can draw the compelling inference that the first appellant had knowledge in this particular case.
is the background and the context are those relevant factors when the judge was thinking whether or not to draw an inference?
Yes, I have to concede that the context is relevant to how one reads the evidence of Magic 3 and what have you. But as I hope I identified earlier, the particular egregious evasion of service which is alleged cannot be traced back to the first appellant. So it's a lot of mud, my lady, but no actual evidence.
Okay.
The same points about inference flows from deliberate non-attendance, ground 6, and the inference that the appellant shared information. That particular one is circular in my submission, because the fact they share information only assists if one of them received the information and had knowledge in the first place. So that circle couldn't be squared by saying essentially, well, it doesn't matter because they shared information.
All right, Miss Pugh, I'm very conscious that you are doing a lot of the heavy lifting for Mr. Leonard. So how are we going time-wise?
Yes, I probably should cede. I think I can be done in 5 minutes.
No, I'm not pushing you to 5 minutes. I just wanted to see how you're doing time-wise.
Yes, Mr. Leonard has very kindly let me go first.
Well, you are the first appellant. And it's very good to see, if I may say so, a junior member of the bar doing the advocacy.
Thank you, my lady. And I should also thank both silks to either side of me for letting me sit at the front bench.
Pleasure.
Adverse
So-
inferences might have been drawn if they hadn't.
Thank you. The reasonable prospects. All I can really say on these, because this is not a rehearing, is that there were plainly tribal issues here. There were 2 elements to the alleged evidence. One dealt with personal obligations, and the evidence there is that the first appellant does not have any assets in the UK, and any assets within the UAE are subject already to an attachment order, which from what I gather is in favour of the respondents already. And it was agreed under the scope of the order, we say any attached assets were excluded in any event. Now, the respondents are sceptical about that, but that is the firm evidence on the personal assets.
Sorry, did you say it was agreed they would be excluded from the order? I thought if I misheard you, then do correct me.
So, I'll remind myself of the exact wording. Is it actually, I think, in the just a Calver order, tab 7.
No, page 71.
Yes, page 71. The worldwide freezing order is varied at paragraph 2. So there is an obligation there to swear an affidavit setting out the details of the attached asset and the order, which measured 3 does either the second appellant. 2. Thank you, Mr. Leonard. There's then disputes of fact about the access of the appellants to information, which is the company's. But the main point is because they do accept that there is information relating to the companies that they have, but then there's this issue about expert evidence. And in my submission, the judge was wrong in his sanction judgment to apply no weight to the issue of Mr. Zaruni's conflict. The authorities are that is plainly a matter that can go to credibility. And the fact that Mr. Zaruni may have personal knowledge and have acted for the appellants and the companies was plainly something which could have had relevance.
But he said expressly in his second judgment at paragraph 48 that my decision did not depend on findings as to UAE law, and he explains why not. Doesn't that mean that this is a bit of a red herring?
Well, that is what the second judgment says, but the first judgment does include it in the reasoning. So in my submission, it still is highly relevant.
Not my fault for not understanding the fact. It's in your case that all the attached assets were covered by what I might loosely call the Zaruni point. In other words, they were all assets that the appellants couldn't talk about because of UAE law. Is that your case?
No, I think there are two points, my lady. I apologise. I'm taking it at a clip and assuming.
No, but it's my fault for not following it. So apologise for interrupting.
So there is the appellants do have assets in the UAE.
Yeah.
But they are all subject to a long-standing attachment order,
Right.
which was therefore carved out of the worldwide freezing order.
But only if they put in evidence about
Yes.
it. So is your case is they did put
And
in the
my
evidence required by paragraph 8 of this code?
Yes.
Right.
So that's my case. And I think it's the second affidavit of the second appellant which sets out the order and the assets that it covered.
Right. Thank you.
The point about the Zaruni evidence is that the appellants accept they have information about the assets of some of the defendant companies,
Yeah.
but they say under UAE law, they're at risk of criminal sanction and civil sanction if they reveal that information without the consent of the companies,
Yeah.
or a UAE court order. So the affidavit of the second appellant says the way to get around this problem is to get an order from the UAE court, and indeed that's what Mr. Al-Ansari says as well, which is an advice attached to the second affidavit of the second appellant, a lawyer in the UAE law who says and gives evidence that yes, they are at risk, and
Yeah.
but you can avoid that risk by getting a court order or getting the consent of the companies. Mr. Zeruni's evidence, but that's not correct, clearly conflicted with the other experts' evidence. And faced with that, in my submission, it could not be said that there was not reasonable prospect of establishing this point. And that would either have gone to contempt and sanction, or it would certainly have gone to sanction, because in my submission, if the appellants had a reasonable belief that providing the information, I'm grateful. I just very quickly on sanction, I can probably be 2 minutes.
No, look.
Oh, I'm sorry.
No, it's all right. I just wanted to do a rain check as to how much longer you thought you were going to be, because everyone needs to have an opportunity. Don't squeeze something in if it shouldn't be squeezed in, all right? Ensure that all the points you want to make are put before you.
Thank you. My lady, of course, I'm just aware that some of my points require a bit more time and others can be are shorter, more discreet points.
That's the skill of the advocate, isn't it?
So the final point, sorry, before I move on to sanction, no, you're quite right, my lady, I did have one more point. The schedule to Mr. Justice Butcher's order with the findings of contempt, just very quickly to go through that so that you understand the first appellant's case. It's at Court Bundle tab 781. I don't expect you to read this, my lady, now, but just to go through the numbers, we say we complied with paragraph 1, complied with paragraph 2, paragraph 3 doesn't apply because there were no relevant assets, so it follows that there were no relevant asset documents. And then that also disposes of the other asset document grounds, 5, 7, 8 and 10. And of course, we have to accept there was a delay in compliance. That's one thing we cannot respond to. But our position is we did eventually comply, subject to this issue about whether we had a reasonable belief. We couldn't comply in respect of the company information. So just moving on to sanction, I don't think there's anything between us on the principles which apply to sanction. We say the approach that the judge took to the appellants as compared to the third defendant is wrong. The third defendant, of course, has not engaged at all in the contempt proceeding.
He was not at liberty, was he? Third defendant.
He's in prison, I understand, from the evidence. I say it was a serious procedural error to hold the affidavit, which I've colloquially been calling Magic 3, essentially against the appellant when it came to sanction, and to grant a lengthier sentence because they had engaged in proceedings, and because without hearing evidence from the appellants, he judged them untruthful in that affidavit. It cannot be right, in my submission, that you can get a longer prison sentence without having the opportunity to defend oneself against that possibility. And then on the other factors, I say that the court didn't take into account the information that was provided in the two affidavits.
You mean which affidavits? Are you talking about M1 and M2? Or
M2 and 3.
2 and 3, right.
Which sought to explain why they complied on the personal obligations and why they felt they couldn't comply as regards the corporate information. My lady, unless I can assist you further, I will yield to Mr. Leonard Casey.
Now, are you sure you've covered all the ground you want to cover? Do you want to do a check just before you sit down?
All right, I think Mr. Leonard's going to deal with the point. Thank you very much, my lady.
Thank you. Mr. Leonard.
No, thank you. I just wonder if I might just grab the lectern from my friend now that she's finished. And agree with the court that a lot of the heavy lifting has been done in relation to the matters before you. And the worst of all worlds would need to simply start repeating things that have already been said. But may I start by embracing two propositions. Firstly, there are aspects of this case, as my own friend has said, which will cause the court concern in relation to the approach taken on a point that wasn't developed in the court below. And particularly, as Lord Justice Bales has identified, potentially, if the appeal is allowed, opening the door to another, forgive my putting it this way, merry-go-round of service attempt and evasion, as no doubt the applicants would put it. But in my submission, the issue of service here is far too important to be seen only through that prism. And it remains a fundamentally essential part of the process to ensure fairness. And what's more, the reason why it is particularly in the interest of justice for it to be addressed in this court is because it wasn't addressed in the court below, and that as a consequence we would submit it, as it were, bleeds into more than one strand of thinking adopted by Mr. Justice Butcher when considering firstly service, secondly knowledge, thirdly reasonable steps, a multiplicity of issues that he had to address. But before I go on to that, can I concede a mistake in my skeleton argument and take it out of your thinking? It's at paragraphs 41, 42 of the skeleton, which will be in your core bundle. I got it separately, but your core bundle divider 6, page 58 onwards. At this point of the skeleton, I suggested that the paragraph 3 of Mrs. Justice Cockrell's order required both postal service and email service at a time when the notification of the listing date was made on or about the 10th of May of 2023. my learned friend and perhaps his junior have pointed out that the subsequent listing order, service order, vacated the requirement for postal service, leaving only, and I emphasise that in the context of this case, only an email address for the second appellant in terms of service from then on. That of itself is quite an important point in my submission. This happens on or about the time of the proceedings, the second service order, back in March of 2022, when, of course, as you know, not only were solicitors on the record, but the appellants, as they now are, were represented by counsel, I think Queen's Counsel, as they then were, in a hearing in front of Mr. Justice Calver.
Sorry, which is the paragraph you want to correct?
It's forgive me. It's paragraphs 41 and 42 of the skeleton, wherein there's reliance is placed on the requirement for both postal service at a villa and you'll see it in bold there, by email. That was a service requirement for the original service order made by Mrs. Justice Cockerell at the first hearing. But in fact, if you look at the second service order, paragraph 68, forgive me, page 68 of the supplementary bundle, at paragraph 1, does the court have that page? You'll see that in paragraph 1, 3.2.1, which is the part of the original order related to postal service that the address we've just looked at was set aside. And so that was my mistake in the skeleton, because essentially the point I was making at that stage was they didn't even comply with the original service order, let alone a service order that had been determined by a separate application in the context of contempt. But in fact, in reality, it takes on a different but equally important significance, because by the time we get to service of the listing date brought forward from the December of 2023 to the October by Mr. Justice Butcher, the only means by which the now respondents, then claimants, were obliged under the original order to serve by then an unrepresented defendant in a foreign jurisdiction, in respect of whom they already had some concerns about compliance and evasion. They were only obliged to serve by a single email address. And one of the concerns this court should have, perhaps, with regard to the nature of this case as a whole, is when a claimant is faced with such a situation, recently unrepresented, disengaged from proceedings, earnest and anxious consideration as to how service is to be effected needs to be given. And in my respectful submission, that is exactly what Mrs. Justice Cockerell was considering in the Ernet mining, Erdnet mining case, back on in the authorities bundle at page 325. And if you would please just look that up for me for a moment, because it really captures the point in my respectful submission. She, of course, is dealing with the old 81.5. I support my learned friend's contention that such distinction or differences there are under the new rule are purely matters of form rather than substance, as they direct the applicant to 66.5 rather than the removed old section of 81. And it would appear that the editors of the White Book agree that the propositions I'm about to remind you of are still good law. It's particularly paragraph 44. Second sentence, under its rules, that's the complete code observation, there must be personal service of the application or an order dispensing with service or an order specifically permitting alternative service. I'm right in the middle of that paragraph. And then this, it seems to me that this is designed to ensure that a court has considered that such an approach is appropriate given the potential sanctions under CPR Part 81, which are of course particularly significant when one comes to the personal aspect of it, where sanctions such as imprisonment may well follow. And there's nothing about that principle, which in my respectful submission, the change in the rules such as they are abrogates, and neither should it. And it would be a very strange day indeed if it had been abrogated, and that of itself meant that every application for alternative service in every case had to consider at the same time that such an application was being made the possibility that such an order would be used in contempt proceedings as well as for the service of ordinary claim documents. And that is simply not being done at the moment, and you've seen our skeleton argument on this. And it would be particularly onerous if that were the case to otherwise claim seeking alternative service at a time when contempt, of course, is not even in their contemplation. The key change here was Charles Russell Speechley's coming off the record in March 2023. And if I could take you back briefly to the order of Mr. Justice Butcher on the 10th of May. And this is at divider 17, this is the listing order. Just so that we're all clear, this is page 140 of your supplementary part. I'm sorry to be dotting around a bit. By this stage on the chronology, it's agreed, firstly, that Charles Russell's speeches have come off the record. So there's no question of solicitors under the new rule being served with the contempt application or associated documents which my friend has dealt with on the authorities. The claimants will have to serve the respondents themselves in a means that means the applications meet their mark. And I just draw your attention to this order because on the last recitation before the order is made, there is no appearance of the defendants. And of course, as I say, there's nobody on the record. And it's at this stage that the hearing of the contempt application is not just listed, as it were, but it's brought forward from December, that being the order made that we've touched on from Mr. Justice Foxton in January of this year, when Millennium Friends say plainly there was still contact with Charles Russell Speechley's, and the December date averred to by Majid 3, that was the last contact he had, is wrong. And Lord Justice Mayles, you addressed the question of the negligence of CRS if they hadn't continued to communicate until they come off the record. Nonetheless, the last order prior to the 10th of May is that these contempt proceedings are going to happen in December.
Can I get this absolutely
Yes,
clear?
of course.
Is the last order Foxton's order in
So what I'm talking about is the Foxton order
January 23 order?
in the January 23, at which point, as has already been observed, by then the appellants today, respondents at that stage, have asked via a previous application for leave to serve expert evidence, and it's that order. But that order also effectively says that the contempt application is listed for December of 2023, and he says, I'm not going to bring it forward. And if one's looking at the chronology and addressing one's mind to the mischief that Erdnet Mining is seeking to assist with, then that's quite an important point in time. So then we get back, if I may, to the 10th of May order. You see on supplementary bundle, page 140, you have effectively the December date being vacated and the 3rd of October being substituted, which is then changed to the 4th. We know about that. There's correspondence in September. But again, for the sake of adopting a posture not unlike a stuck record, at this stage, they're unrepresented, they're out of their jurisdiction, and all that then is done in relation to service of them of this material change is email to a single email address. You'll see that on page 140, the order, it says, order 4 shall be served by the claimants on the defendants. Now, never attractive to be overburdened with hindsight in an appellate court, especially when you're taking a point that wasn't taken below. But one might be forgiven for thinking that at that stage, that was the point in time at which, if I might put it this way, an Erdnet Mining school of thought as to how to manage service of such a changing listing document should have been brought to bear. And just asking ourselves, if I may, this question. With this factual matrix presenting itself to the court, unrepresented, out of the jurisdiction, on one view, evidence of evasion, this court is now embarking on a process, or embracing it on the listing of a process by changing the date, which potentially could put these people in prison. How are we going to ensure that they are served properly and served so that they cannot say they weren't? And certainly it would be open to this court to observe that in a situation like this, in order to avoid this situation again, and that is the point at which greater thought about how to deal with service perhaps might have been brought to bear. And that, of course, ironically perhaps, and I take this point to some extent against myself, applies the greater the problem with service has been.
You mean the evasion point?
Well, the worse it is, the greater, some would say, the onus upon the claimants to ensure in contempt proceedings that bad points, and I put it like that, I hope the court understands why, can't be taken. And again, we look back in our rearview mirror at the Erdnet Mining Authority, again, in my respectful submission, that's exactly the sort of consideration that Mrs. Justice Cockrell had in mind, and for very good reason, we respectfully suggest. My respectful submission is that it is an overwhelming likelihood that if an order such as Mrs. Justice Cockrell, no, it was Mrs. Justice Cockrell and Erdnet Mining had been sought, the very least that would have been reinstated as an alternative service, perhaps with personal service on top of it, would have been the postal service requirement that had been vacated by Mr. Justice Calver. At the very least. Arguably, even more. The whole panoply of effort, for example, used to communicate the 4th of October decision of Mr. Justice Butcher to the appellants on or about the 10th of October could well have been a reasonable starting point. But as it was, as we've already touched on, I don't want to repeat myself, no such application was made. But the idea, if it be offered, that had that application been made, that only the single email address as a method for service, alternative service, would have sufficed, it is, in my respectful submission, fanciful. It simply wouldn't have been left like that. Again, I don't know, I don't want to take the court to documents that it's already read and has a feel for, but it may be illustrative to understand how this was addressed at the 4th of October hearing. And my starting point for that is my learned friend's skeleton argument at that stage, which you'll find at the supplementary bundle at page 287. Because it might be asked, might it not, whether or not, and if so, to what extent the AirNet mining issue was considered by Mr. Justice Butcher. My respectful submission inferentially is that it may not have been, albeit that it was flagged by my learned friends in their skeleton argument at supplementary bundle 294 in a footnote. That's not a criticism, that's an observation. Does the court have footnote 35? And looking above the page, that footnote is pegged specifically to paragraph 28 of the skeleton argument and the issue of service and failure to appear.
Sorry, can you just allow me a moment?
Yes, of
So I
course.
can read it. And that is linked to which paragraph?
28.
Thank you.
And it's specifically the sentence that reads, the contempt application must itself usually be served personally unless the court directs otherwise in accordance with part 6. That's the new CPR 85.1 provision that we've already looked at. And then the footnote below says this: prior to the reform of CPR 81, an order for alternative service documents generally in the proceedings would not suffice, because CPR 81 was a complete code, a distinct regime, and included distinct provisions for alternative service. And it then quotes directly the old CPR 81.10.4, and in fact draws specifically in that regard on the case of AirNet mining, which it's effectively offering for the proposition that I've just identified. But it then says, however, and one can only assume my own friend's point here is that obligation has now been abrogated by the, quote, new streamlined CPR 81, specifically contemplates that the court may otherwise direct in accordance with part 6. So the point seems there to be made that the alteration in the rule has meant that the previous practice, and I would say supported well by authority of a separate order within contempt proceedings, has been abrogated. But what's apparent, and we can look at this when we come on to the transcript of the hearing, is that there is a sense in which that point was never engaged with. And from our perspective, in our respectful submission, it is difficult to see how it could be said that Mr. Justice Butcher addressed his mind to this separate service order, because we say plainly he didn't. And I'll take you now to, if I may, the hearing transcript, which appears at the supplementary bundle 319. And just to give this context again, this is the hearing at which the appellants did not attend. It's the brought forward hearing from the December, firstly to the 3rd, but then to the 4th, notification of that second change communicated to the second appellant only again by email. That much is covered in the evidence of Mr. Richards instructing my own friend. And you'll see on page 319, at the bottom of this page, Justice Butcher asked my own friend, Mr. Peter, King's Counsel, what I want you to show me is the document relating to the service of the contempt application, and then this, and the service with notification of the listing of this hearing. Now, having, as it were, set that hare running, there follows a series of exchanges, if I might say so, primarily with regard to the third defendant. You see his given name halfway down, or about a quarter of the way down the page that follows. And there's discussion of him being served validly through Abdullah or Majid, the first and second appellants before the court today, pursuant to 4.2 of the alternative service order made at the return date, which again, by this stage, just for emphasis, if you'll forgive me, is against Mr. Majid Al-Sari by email only. Then there's further discussion at the bottom of that page, again about serving Muhammad Al-Sari in relation to Abdullah or Majid by any permitted means. Then at the bottom of the following page at 321, my learned friend, again having dealt with other issues to do with Muhammad primarily, takes my Lord Mr. Justice Butcher back to the original question, and he emphasises at the bottom of that page, not the listing order that I made when it was served, and Mr. Peto says at the top of the page that follows, this is in fact page 282 of your appeal supplementary bundle, but it was the core bundle for that hearing at 1705, dealt with in Mr. Richards' fifth affidavit, which is where my learned friend says the list starts, and that's a list of how individual defendants were served. And then Mr. Justice Butcher asks again, the next point is, have they also been informed of the date which is set out in my order? Third was not right, and it was the fourth. And my own friend replies, yes, paragraph 22 on the same page. Jones Day wrote to each of Muhammad Al-Sari and former CRS defendants by the method set out in paragraph 21.1. And it may just be as well for us to look at page 282 for the source of this being looked at by my learned friend and Mr. Justice Butcher. I'll give the court a moment just to find that. 282 of the supplementary bundle. Does the court have that? It's paragraph 21.
Divided 24.
Thank you. So sorry, because I'm
No, it's all right,
electronic,
don't
I
worry.
haven't got tabs in mine, I'm afraid. This is a list of how it is that each of the individual defendants were served with the 12th of May order. Does the 10th of May order, forgive me, does the court have that?
Yeah.
Each one identifies 12th of May, this is what we did. I focus, of course, particularly on paragraph 21.2, Majid Al-Sari on the 12th of May 2023, listing order was served by email to Majid at falloil.co.ae as permitted by 3.2 of the service order.
Well, what they are doing here is going back to the order of Mr. Justice Calver.
Yes, so well, both really, because
Yes.
they're going back to the original service order, but because Mr. Justice Calver, my mistake, had removed the postal service, all we've got left, legitimately, if that were the only order that was needed, is the email address that we see set out at 21.2. So I don't want there to be any misunderstanding. If no further order was needed in the context of the contempt proceedings, or if, for example, this one was another document within the underlying claim, and the point may still be made that they're by this time unrepresented and out of the jurisdiction and so forth, even for a document of that sort, by this stage, and I don't mean this in too pejorative way, all they're doing is sending notification of this hearing to a single email address from which, and I'll come to this, as I understand it, there's never ever been any response backwards.
So what this comes to, is this fair, is that the claimants did serve notice of the hearing in accordance with Mr. Justice Carver's order.
Yes, correct.
The question whether that was sufficient in the sense of being applicable to the contempt proceedings was simply not addressed
Yes.
beyond the footnote in the skeleton that you showed us. And that's
That's exactly it. And I put that before the court because no doubt the court would want to know how issues such as the adnet mining approach was captured and dealt with. And with great respect, it doesn't seem to have been in the detail that it might have been, because otherwise, no doubt, an application for alternative service would have been made for the contempt. Arguably, anyway, because again, even if they're unrepresented in the substantive claim, irrespective of the contempt proceedings, again, all that's being used is the email address, whereas before they had obviously the means of serving CRS as the solicitors on the record. So things have materially changed. And just to complete the picture, if you look over the page at paragraph 22, conscious of the time, I will just deal with this point and then take stock of how the court would like me to proceed. Remember, we've talked about the 3rd of October being moved to the 4th of October, the original order being the 3rd of October. Paragraph 22 captures what happened to that date change from the 3rd to the 4th, and essentially what's happened is that they've done exactly the same thing. They've written to Majid at that same single email address to advise him of that change of date from the 3rd to the 4th. There's no difference in service of that second date. May I just finish this side of the short adjournment, subject to the court's better view, with where we got to in relation to the transcript of the hearing of the 4th of October.
Well, what you showed us is that the point that you're now taking was simply not addressed.
Yes,
and the judge moves on to the rest of the checklist.
and indeed, that's exactly what he says. If you look at page 322. The exchange is about service being completed. My transcript doesn't have letters, but it's about the 7th line up from the bottom in relation to service. Mr. Justice Butcher said, so that deals with the first point of the checklist. And of course, at this stage, we're addressing a checklist for proceeding in the absence. And that is, ironically, the test that again comes from the adnet mining case, where Mrs. Justice Cockrell, I think, repeated somebody else's checklist, but nonetheless, it's in there and relevant for this from this point. And so, just to finish with before the short adjournment, from this moment onwards, we have a problem in our respectful submission with how, not only, forgive me for putting it this way, the claimants are dealing with service, but how the court has been allowed to see that service has been properly made. And of course, just to think about it in context, and ask yourselves perhaps this question: if at this stage somebody had said to Mr. Justice Butcher, well, actually, the normal way now is to serve an additional or have another application in the context of contempt proceedings for alternative service, that hasn't been done. We're going on the original single email order. Again, we've got 2 unrepresented defendants out of the jurisdiction, and we've got this email address, but that's all we've sent these documents to. Would Mr. Justice Butcher have gone ahead with that hearing? on that day and made those findings. My respectful submission is there's a very strong probability that he would not have done. In which case, we wouldn't be here now. Well, I say that maybe in a slightly different form, who knows, but I wouldn't want to rule it out. But nonetheless, we wouldn't be here now arguing this point. And so going back right to the beginning of Malone and Friend's submissions when Lord Justice Mail asked her about the interest of justice and this taking this new point on appeal, I hope that goes some way to seeing that it is in the interest of justice or supporting that submission because of the way it was dealt with in the court below and the fact that early decision has bled that service assumption into everything that happened thereafter, because of course it feeds into knowledge, reasonable steps if you want to go wind forward to the set-aside application. Even Malone and Friends Yates, who appeared for the appellants at that hearing on the 27th of November, proceeded on the basis, self-evidently, that service had been proper and there was no issue about it. Everybody else had, so he's just the next one.
Well, it's perfectly possible that they were not validly served, if you're right about the submission, that there needs to be separate consideration at the contempt stage, but they nevertheless knew.
Knowledge.
Those are separate points, and there is a finding of actual knowledge.
That there is, but that finding of actual knowledge can only have its genesis in an assumption that service had been proper in the first place, because that must be relevant to knowledge as well. So you can't, in my respectful submission...
No, it doesn't necessarily, because there's an alternative source of knowledge, namely the correspondence with acuity law.
Yes, but that's not said to be with the second appellant, unless, of course, you go down the road of making an assumption that Abdullah, the first appellant, and Majid, the second appellant, must have communicated about the acuity law issue, which in my respectful submission is not much beyond speculation as opposed to inference. But the acuity law point rests with Abdullah.
I mean, it's clear they're in close contact because one is making affidavits on behalf of the other.
Absolutely, and of course those are not irrelevant considerations. But if you ask yourself, how did the decision about knowledge come to be reached from a broad spectrum perspective, the very acceptance of service in the first place must, in my respectful submission, have played a significant part in that regard. And equally, if it had been realised that service hadn't been proper, would they really have gone down the knowledge route with that in mind? Because first of all, they'd have had to consider a separate alternative service application, and any number of other procedural issues would have arisen. And so it's in my respectful submission very much the starting point from which then assumptions are made that affect the way in which the whole proceeding then unfolds.
But as Lord Justice Males was pointing out, there is a distinction between service and knowledge, and the whole point about formalities to do with service is that if they've been complied with, then you're fixed with the knowledge whether you've got it or not.
Understood. Can I?
Yeah,
forgive me, I interrupted. No, I interrupted.
No. So I mean, I'm just emphasising that there is an important distinction, and in a way, your submission is that the judge was not aware of that important and basic distinction.
No, he wasn't aware that service hadn't, as we would say on the point we now raise, been done effectively and properly in accordance with the ordinate mining principle. That's the point. And if he'd known that, that step had been missed out, forgive me putting it that way, it hadn't been undertaken, then we wouldn't have, submit that this is a perfectly reasonable place to go, we wouldn't have got to the knowledge at this stage because we'd have focused on service because service hadn't been done properly.
No, but we might not have done, but you seem to be suggesting that we must understand that the judge didn't understand that there is an important distinction between the formalities of service and actual knowledge.
Forgive me, I hope that's my clumsiness. I didn't mean to make it
may be
quite
my
that way.
fault. I'm not.
But what I do say is that they in this particular context, it is all but impossible to separate them in terms of influence.
Right.
Because, of course, if Mr. Justice Butcher, conversely, had determined that service hadn't been proper, of course, my lady, you would no doubt say to me, well, he could then have gone on and considered actual knowledge nonetheless. But of course, the counterpoint to that is if he realised service had not been properly effected, and realised, again, forgive me, the checklist is mine now, 2 unrepresented defendants out of the jurisdiction and 1 email address using to serve, my respectful submission is the overwhelming likelihood he would want to regularise service by addressing alternative service of the contempt proceedings before proceeding any further.
Right, thank you. We rise now, 2 o'clock.